Welcome to The Explainer. Today, we're going to dive into a really strange corner of the law, the world of what are called inchoate or incomplete crimes. We're talking about crimes that get you into trouble even if the big bad thing you were planning never actually goes down. So let's start with a question that sounds kind of impossible, right? How can you actually be found guilty of a crime that never even happened? Why would the law punish somebody for just talking about doing something? Well, it turns out there's a really good reason for it. All right, so to really get this, we've got to break down the crime of solicitation. And it's kind of like a recipe, really. You need two very specific ingredients, and if one is missing, you just don't have the crime. So on one hand, you've got the actus reus, which is just a fancy legal term for the guilty act. Let's just call it the ask. And on the other hand, you've got the mens rea, the guilty mind, or the intent. You have to have both of these, no exceptions. So let's look at that first ingredient, the actus reus, a little closer. The heart of it is simply the communication. It could be words you say, a text you send, even an old-fashioned letter. It doesn't really matter how you do it. The point is, you, the solicitor, have done your part to try and get the crime rolling. And here's where it gets really interesting, and it's a super important point. The crime itself is completely done the second the request is made. It makes absolutely no difference if the person you ask just laughs and says no way or totally ignores you. They can even be an undercover cop. And why is that? Because the law is designed to stop the danger right at that moment, the second someone tries to put a crime into motion. And this whole idea was really hammered home in a case called State v. Davis. The court basically said, look, we're not focused on what happened in the end. We're focused on the danger created by the solicitor just trying to get someone else involved in a crime. It's really about punishing the act of trying to pull another person into criminal activity. Okay, so that was ingredient one. Now for number two, the mens rea, the guilty mind. And this isn't just, a bad thought you have for a second. The law demands what's called specific intent. And that actually sets a pretty high bar for any prosecutor who wants to prove it. So think about it from the prosecutor's side. They have to prove this was way more than just idle talk. It wasn't a joke. It wasn't somebody just venting and blowing off steam. They've got to show that the person who made the ask genuinely, truly wanted that crime to happen and was seriously trying to make it a reality. Okay, so this is where things get a little weird, a little tricky. Solicitation, remember, is just a starting point crime. And sometimes, if the plan actually moves forward, that solicitation charge, well, it can just kind of vanish. Legally, this is called the doctrine of merger. Think of it like this. Committing a crime is like going on a road trip. The first step, just asking someone to go with you, that's solicitation. But what happens if they say yes? Well, you've just moved on to the next stop on the map, which is conspiracy. And when that happens, the original solicitation charge gets absorbed or merges into the bigger, more serious crime, because the whole situation just got a lot more dangerous. Let's make this super concrete with a bank robbery. Step one, person A asks person B to rob a bank. Boom, right there, that's solicitation. But the second B says, I'm in, the crime changes. It's not just solicitation anymore, it's a conspiracy. The law looks at that agreement as a much more concrete and dangerous step, so the first charge just merges right into the new one. And that's the bottom line here, right? The whole point is to avoid punishing someone twice for what is really just one single criminal idea that's moving along through different stages. The smaller crime gets swallowed up by the bigger one. Okay, so this probably has you wondering, what if you ask someone to do something terrible, but then you immediately get a knot in your stomach and think, oh no, what have I done? Is there an escape hatch? Can you actually take it back? It's interesting. The law has kind of had two minds about this over the years. The old school rule, the common law, was super strict. It was basically, nope, no takebacks. You said it, the crime is done. But the more modern way of thinking, which comes from something called the Model Penal Code, actually gives you an out. It's a defense called renunciation. And the whole idea is to encourage people to stop a crime before any real harm is done. But listen, this escape hatch isn't some get-out-of-jail-free card. The rules are really strict. First, you have to back out completely voluntarily. It can't be because you think the cops are about to show up. It has to be a real change of heart. And second, you have to be the one who actually stops the crime. You have to convince the other person or do whatever it takes to make sure it doesn't happen. Just saying, never mind, probably won't cut it. Okay, so we've covered a lot. How do we actually put this all together and use it to figure out if a crime happened in a real-life situation? Well, it really just boils down to a simple checklist. And this simple checklist is basically your playbook for breaking down any situation you might see. First, look for the act. Was there a clear ask? Second, weigh the intent. Was this person serious? Third, check for merger. How far did the plan actually go? And finally, number 4, you gotta ask, did the person try to take it back, and did they actually succeed in stopping it? All right, to wrap things up, let's throw a little scenario your way to put this all to the test. So a student offers their tutor $200 for a copy of the final exam. The tutor is completely shocked, says no, and tells the student they're going to report them. So using that 4-point checklist we just went over, is that student guilty of a crime? We'll let you think that one over.